In the next session, we have invited distinguished IP practitioners and regulators to share how Hong Kong could make use of our robust and transparent IP protection regime and experienced legal service providers to develop into a regional IP trading hub. Our speakers are Mr. Alan Chiu, founder and managing partner, Alan Lan, Ms. Rebecca Low, consultant, Galen, and Mr. Thomas Tsang, Deputy Director of Intellectual Property of the Hong Kong SAR Intellectual Property Department. This session will be moderated by Mr. Arthur Law, General Counsel, Meitu Inc. Please join me in welcoming the panelists to the stage.
Hi, everyone. My name is Arthur Law. I'm the General Counsel of Meitu Inc., a Hong Kong main board listed company. So welcome to the fourth panel discussion session today, which is Advance Your IP Literacy as Hong Kong develops into a regional IP trading center. So as all of you would know that IP is very crucial in driving growth and innovation in today's knowledge-based economy. As Hong Kong sets out to develop into a premier IP trading center in the region, speakers in this session will look into Hong Kong's strengths in terms of legal system, IP regime, and its close link with mainland China, and see how these advantages could be leveraged. So without delay, let me introduce today's speakers to everybody. Our first speaker today will be Mr. Thomas Tsang. Thomas? Thomas is the Deputy Director of Intellectual Property of the Hong Kong Intellectual Property Department. So as a public officer, Thomas has a professional experience in advising the Hong Kong government on and addressing a variety of legal and policy issues, mainly arising from IP legislative exercises covering copyright, trademarks, and patent areas. And today, Thomas sharing a session will mainly focus on the policy and the government incentive level. And the main topic he'll be sharing today is called Hong Kong as a Regional Intellectual Property Trading Center. Okay, so that's Thomas, the first speaker. And then the second speaker here we have is Ms. Rebecca Low. Ms. Rebecca Low, give her a round of applause, thank you. So Rebecca has been practicing the law of intellectual property, technology, and media and communications for more than 30 years. And she's a very well-qualified lawyer, I must say, qualified in Hong Kong, California, Singapore, England, and Wales. And she's a notary public and also a China-appointed attesting officer. So today, Rebecca will be sharing on the mainly called the IP asset, which will cover the IP fundamentals, as well as what companies should be doing to protect and maximize their IP asset. So and then now we have our third speaker, last but not the least, Mr. Alan Chiu. Alan? Thank you, Alan. Alan is the founder and managing partner of LLM. He specializes in IP, technology, and entertainment matters, and he's an award-winning lawyer, winning over 50 professional awards. And today, Alan will be sharing on practical tips for effective management of IP assets, which will cover the Madrid Protocol, practical tips for IP licensing, IP documentation within a corporate, especially focusing on AI policy. So may I take the opportunity now to invite Thomas to deliver his first sharing session. I think, Thomas, each of our speakers have some slides today to share with everybody. Thank you, Thomas.
Thank you very much, Arthur, for your very kind introduction. Rebecca, Alan, distinguished speakers, distinguished guests, ladies and gentlemen. May I first of all thank the Law Society of Hong Kong for inviting me to join this panel with two IP experts this afternoon for knowledge dissemination as well as experience sharing. It gives me great pleasure to see you all in this afternoon. Well, before I go into the substance of my presentation, I would like to do some management expectation of my presentation. Well, I can assure you that every speaker wishes to offer the audience as many takeaways as possible, but we all appreciate that this is mission difficult, if not impossible, given the constraint of time. It is my humble objective that by the end of my presentation today, you would not only acquire a better understanding of the concept of IP trading, and I would also like to invite you to think about the business opportunity afforded by the government's initiative in developing Hong Kong into an IP trading center, and to think about how best you, your firms, or even your clients may utilize IP to develop your business strategy in order to enhance your business model, in order to grasp the opportunities ahead for promoting further business growth. Well, without further ado, let me proceed with the substance of my presentation today. To facilitate the understanding of my department, which was established back in 1990, basically, the department is responsible for providing responsive and quality registration services for trademarks, patents, and designs, as well as copyright licensing bodies to the public. And the IPD is also the legal and policy advisors for the government for pursuing different types of initiative for promoting IP literacy, as well as, most importantly, IP trading in Hong Kong. And the other very important function is we have to interact with the public, the practitioners, stakeholders, and industries in order to enable them to appreciate the importance of IP and to promote IP literacies amongst the public as well as the society. Well, actually, this short video was prepared back in 2020 when my department was celebrating our 30th anniversary. It actually contains 12 milestones, which I think it will be useful to let you know the path which Hong Kong has gone through for the past years. So allow me to in the video, you will appreciate that there are various milestones which Hong Kong has gone through in developing our IP regime. Here is the structure of the Hong Kong government and also the position of IPD. I would like to show that in addition to IPD, there are indeed quite a few policy bureau as well as government department which their duties are closely related to IP. For example, I've highlighted those policy bureaus as well as government department in bold. For example, the Customs and Exiles Department, the department is one of the very core functions on duties of the department is to enforce, to conduct criminal actions against infringement of IP, namely trademarks and copyright. And we also have the Department of Justice, who is the civil advisors of the legislation in Hong Kong. And whenever we wish to enact any piece of IP legislation, we have to work with the DOJ as our very close partner in order to, for example, render the necessary legal advice as well as formulate the relevant draft provisions. In terms of the Policy Bureau, IPD is under the Commerce and Economic Development Bureau, which one of the very important function is to promote IP as well as to draw up the necessary initiative to achieve the purpose. There are two important government bureaus whose functions may also be closely relating to IP. Is the Innovation Technology Industry Bureau, which is promoting innovation technology in Hong Kong by investing billions of Hong Kong dollars to promote creations of inventions. And also the Cultural, Sports and Tourism Bureau, which is promoting Hong Kong as a cultural exchange center, which would give incentives to stakeholders to generate a considerable number of works, typically copyright works in the form of, for example, books, music, television programs, dramas, etc. To give you an idea as to the recent registration figures of the department, I've prepared a table for you. I would like to draw your attention that, well, actually, we have Hong Kong does have considerable number of IP in terms of patents, trademarks, as well as registered designs. And these IPs contains values which can be commercialized and can support the growth of our knowledge economy. It's very important for members of the audience to understand the big picture before understanding the government, the rationale of the government in promoting IP trading in Hong Kong. It is important to note that our motherland, China, also attach great importance to IP these days. And in the National Development Strategy, the Chinese government expressly proclaimed that China is going to be a leading nation in intellectual property rights. And under the national policy, the central government also supports Hong Kong to promote or to develop Hong Kong into the 8 centers. And one of the centers is known as the Regional IP Trading Center. And in fact, the National 14th Five-Year Plan, promulgated in March 2021, expressly or raises the first time national support for Hong Kong to develop into a regional IP trading center. Now, to go into IP trading, I would like members of the audience to bear in mind there are various important elements which actually constitute the overall picture of IP trading. Well, first of all, when we are talking about IP is basically intangible assets comprising, for example, trademarks, copyrights, the designs, registered designs, as well as patents, and even trade secrets are also covered and protected as IP. And it is very important that we have creation and we are able to identify the existence of IP in the first place before the chain reaction takes place. The second very important element, which the government has spent considerable resources in strengthening, is protection of IP. The value of an IP asset essentially comes from the right of the asset owner to exclude competitions, to exclude competitors from using the IP. And such value is capable of generating a measurable amount of economic benefits to its owners as well as users. And so it is also important to make sure that there is sufficient protection of the individual IP rights, which would create or add more or extra value to the intangible assets. And the third element is management of IP rights, because there is really no point to simply register a trademark and then get a registration certificate and then store your certificate in your drawers. that does not actually maximize or utilize the inherent value of intellectual property assets. So right owners, or they may even instruct agents or their lawyers to properly manage their rights. For example, by regularly doing IP audits, or when there is any infringement, they need to take enforcement action as quickly as possible. And the fourth element, of course, in support of IP trading is commercialization. And commercialization actually takes various forms. As we all know, it can take in the form of acquisition, and in acquisition of, for example, a company's assets comprising IP, and it can also be in the form of, for example, licensing, whereas the owners retains the exclusive right of the property, but allows a third party to use the property either on exclusive or non-exclusive basis. And I would also like to draw members of the audience attention that, as I understand, I understand you are all lawyers, private practitioners, or even in-house lawyers, and I can assure you that you can also play a very important role in support of the IP ecosystem, because each of these elements would require professional service in order to enable or to facilitate, for example, creation, protection, management, and commercialization. And as lawyers, you will be able to advise your clients, and you'll be able to help your clients, support your clients in doing different transactions, as well as dispute resolution of IP disputes. We have to recognize the inherent strengths of Hong Kong in promoting Hong Kong as a regional IP trading center, and I've actually identified 4 blocks. First of all, we all agree that Hong Kong has a very sound legal as well as judicial system, and Hong Kong should be proud that we are the only common law jurisdiction actually using English and Chinese as official languages. And our Hong Kong laws, our Hong Kong courts, we have judicial independence, which would give investors as well as IP owners the confidence in our judicial and legal system in getting the dispute resolved. And we have a very solid foundation for the rule of law, namely our law is certain and our law is easily accessible to the public. Second, which is very closely related to our strong legal system, is Hong Kong is maintaining our robust IP protection system. The Hong Kong IP legislation, as well as the legal system, actually meets the highest standard, international standard, set out in the World Trade Organization TRIPS agreement. And the Hong Kong government is committed to enhancing and strengthen our statutory regime from time to time in order to meet the necessary economics and social needs. We have also a very strong and highly developed as well as reputable services industries. And of course, our legal practitioners would take pride of that. Our professionals, whether it's in legal field or not, they are all skilled professionals with knowledge as well as expertise in order to help their clients and advise their clients in various transactions. And many of our practitioners, they have the international perspective as well as the mainland perspective, and they are all proficient in English, Cantonese, as well as Putonghua, which would add value and also enable them to provide comprehensive professional services to clients for their benefits. The 14th five-year plan, in addition to supporting Hong Kong to develop into a regional IP training center, also support Hong Kong to develop into various centers, covering, for example, the international innovation and technology centers. The government, as I've said, has invested billions of dollars in the industries and in the R&D sectors in order to enhance our IP ecosystem, particularly in creating and generating more inventions with commercial values. And the second center is known as the East Meets West Center for International Cultural Exchange. And of course, in promoting our position, we have to diversify our development of our cultural and creative industries in order to reach out to the international markets. And in the process, as I have briefly mentioned earlier, various works or various assets which are capable of being protected by IPs, for example, books, music, movies, they are all intangible assets of cultural and artistic significance. And in doing so, it will also complement our efforts in promoting IP trading. Now, of course, another very important objective or initiative which our colleagues in the Department of Justice is pursuing is promoting Hong Kong as a center for international legal and dispute resolution services in Asia-Pacific region. In Hong Kong, we have established a specialized list in the Court of First Instance, in which judges specialized in IP would be responsible for dealing with IP case with the view to adjudicating the case expeditiously. And in Hong Kong, we also have introduced a number of statutory amendments in order to promote dispute resolution. One of the amendments is the amendments to the arbitration ordinance, which makes it very clear that all IP disputes are arbitrable and IP awards are enforceable in Hong Kong. And there is also collaboration between the mainland in recognizing judgments in Hong Kong as well as in the mainland, and the judgments actually covers IP judgment. The initiative the latest status is that we have passed the necessary ordinance, and the colleagues in the DOJ as well as in the mainland, they are working together in order to prepare the necessary rules in order to implement this initiative as early as possible. We have our opportunities in developing IP trading because Hong Kong now has a role in participating in national and international dual circulation economy. And actually, the Guangdong, Hong Kong, Macau Greater Bay Area, known as the GBA, is also a market of potential because it ranks the second in the top performing science and technology cluster, which generates a number of IP assets, which means that there is indeed a great demand for IP and a great demand for IP services in the region. Given the constraint of time, I would like to briefly introduce the latest initiative of the Hong Kong SAR government in promoting IP trading in Hong Kong. The roadmap was actually set out in the Chief Executive Policy Address last year. And the roadmap basically is divided into three categories. One of them is in enhancing the IP protection regime, which IPD is taking a leading role in advancing these projects. And the second area is capacity building as well as external promotion. Now, in various types of IP, trademarks, copyright, patents, and designs, there are quite a number of initiatives for IPD to press ahead with. In trademarks, we're actually pressing ahead with the preparatory task for implementing the Madrid Protocol to Hong Kong by the central government. We have already enacted the principal ordinance to provide the necessary power to the registrar of trademarks to enact the necessary rules for providing for the rules and procedures and requirements for implementing the systems. And we are actually working very hard with the Central People's Government to settle the implementation details before the central government is in the position to extend the application of the international treaty to Hong Kong. Copyright, following the amendment of the Copyright Ordinance by the Copyright Amendment Ordinance 2022, which has come into effect since the 1st of May this year, we are preparing for embarking on the next round of review to make sure that our copyright regime would adapt or would be able to support the growth of our knowledge economy. For patents, since the implementation of the original grant patent system in 2019, which provides a direct route in Hong Kong for applicants to apply for standard patent in Hong Kong, we are actually enhancing the substantive examination capacity under the current regime. At present, we are enlisting the technical support of the Patent Office in China to process patent application, but we have our objective to enhance our substantive examination capacity by increasing the number of patent examiners. Hopefully, it would be increased up to 100 so that the Intellectual Property Department, the Patent Registry, will be able to conduct substantive examination by 2030. And next year, we will be starting another very important project for our Registered Designs Ordinance, which was enacted back in 1997 without major amendments or without any major review. Our target is to start a review of our registered design regime and to study the issues, and as well as identifies the issues which requires updating, and we will strive to commence a public consultation the year after in terms of the way forward to enhancing the regime. Now, for capacity building, the policy address also set out the target that we have to provide IP training to different industries across the board in the current 5-year term of the government. And one of the major programs which IBD is implementing is the IP Manager Scheme, which we would organize training course for example, different industries for the SME to attend the course, to let them appreciate the importance of IP and the potential value of IP, and to let them have some of the practical tips in order to manage, protect, as well as to commercialize their IP. And at the same time, we are also collaborating with our partners, the Department of Justice, in order to promote IP mediation and IP arbitration as an alternative dispute resolution, which provides an alternative route to resolve dispute instead of just conventional litigation. And we are also very happy to have the support given by the Law Society for Hong Kong in organizing or in arranging for the IP-free consultation services, where we have already increased the duration of consultation and increased the number of legal advisors early this year to provide a free consultation session to SME to answer their inquiries about IP management or protection in their individual cases. And for external promotion, I would like to highlight a very important event, a flagship event, which the Hong Kong SAR governments jointly organized with the TDC, the Trade Development Council, as well as with the design centers, Hong Kong design centers, to promote IP in the international community. And the event is known as the Business of Asia, or Business of IP Asia Forum, which is going to be held on the 7th and 8th this year, with the theme of IP and innovation, steering new economic growth. And at the same time, we have also a number of programs for the youth where we would, for example, send our ambassador for IPs to local schools to enable our young people to understand more about IP rights, the opportunities which Hong Kong offer, and so that they know it as a means of, for example, stimulating their creation mindset and to provide a career path for them to pursue in the IP community. Well, I'm really sorry that I have to rush through the topics because I have to allow sufficient time for two legal experts to speak to you, to share their tips in protecting or in commercializing IP. And of course, after the presentation, I'm happy to take any questions from the floor. Thank you very much.
Thank you very much, Thomas. So now, Rebecca, if I may invite you now to share your session with the audience. Thank you.
Good afternoon, panelists and fellow lawyers. Today, I'm going to share with you some information about the importance of IP as an asset of the company. Now, first of all, let's take a look at this chart. It tracks the components of S&P 500 companies, all right? And of course, as you know, S&P 500 companies are all US companies. But if you take a look at this chart, tracing from 1975 all the way up to 2020, you will realize that the IP component in the companies have grown significantly. In 1975, only about 17% of a company's assets or the capital value is in relation to intangible assets. By 2020, 90% of the company's capital value is in relation to intellectual property asset. And because IP is such an important asset, I think this gives you all very good reason to understand more about IP. Now, some people may have the misconception that IP is only for technology companies, or IP is only for big companies. But actually, IP is prevalent in all businesses, whether you're big, you're small, whether your business is in relation to technology or finance or food and beverage, anything, actually anything, all right? Now, of course, we all have company names and logos. We have work products, for example, work manuals, etc. We have technology, know-how, company lists, business goodwill, etc. All of these are prevalent in all companies. And for the IP lawyer, we apply the laws of IP, namely trademark, copyright, design, patent, trade secrets, and passing off to protect these assets. Now, may I spend just 20 minutes to take a look at the IP asset? First of all, trademarks. Trademark can be a registered right. It can also be unregistered rights. However, of course, registration will give you a lot of more benefits in terms of enforcement. It protects brands and names mainly. Registered design, or in other jurisdictions, they may be called other names, such as design patents, etc. They are registered rights. In other words, if you don't register, you don't get protection. And it protects the appearance of products. Copyright is a right that does not require registration for enforcement. However, in many jurisdictions, there are voluntary registration of copyright. Copyright mainly protects original works, literary works, musical works, photography, films, sound recordings, and even the performers' performances. Patents are registered rights. In other words, again, if you don't register, you don't enjoy the protection of a patent. And it mainly protects new inventions. Trade secrets, of course, as the name implicates, it is not a registered right, all right? Because you put it in the shelf, lock it up as a secret. So you will not be putting it up for registration. It protects confidential information, such as customer lists, market strategy, etc. And all of these are actually rights that can be used. Now, how can you make use of IP for a company? First of all, IP differentiates your business from your competitors. It helps you maintain competitive edge, keep competitors off the market, as well as bring income through collaborations such as joint ventures, all right, licensing, franchising, etc. IP also supports businesses in getting funds for development. Now, from the SME to the big companies, they all go through various stages of development. And throughout these stages, IP is a very good support. When you're a startup, IP helps you apply for government funding and get incubation support. You can also seek investors or venture capitalist funding because you have a good IP portfolio. You can seek bank loans, all right? And you can use your IP as collateral. And finally, you can also raise funds through listing. And may I just mention that there are special listing rules for biotech companies as well as specialist technology industries. IP also supports business growth. IP can be used for yourself, all right, to oust your competitor, to maintain a competitive edge, or you can use it to collaborate with others. And through such collaboration, licensing, and franchising, you can quickly expand to new business areas and new territories. You can increase market share very quickly, increase income, and use as a chip to negotiate for settlement of disputes. You can engage in cross-licensing so as to get desired technology that you are not able to develop yourself, but you want, so you can trade. You can also attract strategic partners with your IP portfolio. Now let's take a look at some of the big M&A deals which are driven by IP. These are just some random selection, all right? Facebook acquiring WhatsApp, because at that time, they are one of the easiest to use instant messaging technology. Dow Chemicals acquiring DuPont because of the cancer treatment portfolio. Disney acquiring 21st Century because of the movie library. And Microsoft acquiring Activision Blizzard because of the video game library. Now, let's also take a look at China. On the left are inbound investments into China. And on the right are outbound target companies. Now, for inbound investment, for the top 50 deals in the years 2019 and 2020, in the 2 years, the top 50 deals, the first jurisdiction, the top jurisdiction that invests the most number of deals is US, and Hong Kong ranks the second with 11 deals amongst the 50. And when it comes to outbound target companies, for the top 50 deals, Hong Kong ranks number 1, 11 deals. So you can see how significant Hong Kong is, playing a role in the investment, inbound or outbound, relating to China and connecting with the world. So for China inbound M&A within the past 2 years, in the years 2019 to 2020, the top 50 deals involves financial services, software and services, healthcare, and professional services. And you can see a lot of these industries involve the use of technology. As for outbound M&A, the top 50 deals involves metal and mining, software and services, healthcare, food and beverage, and energy. Again, many of these involve technology because even though on the surface, for example, food and beverage, you may not link it up with technology, but actually there is a lot of use of technology for delivery, for the handling of logistics. Technology is now everywhere for the efficient operation of a company. So as in-house lawyer or as outside counsel advising companies, you have to pay attention to intellectual property. So, the following part of my presentation relates to what companies should do to protect and maximize their IP asset. The most important and foremost is to develop an IP strategy, to establish policies and procedures relating to the creation, identification, protection, and reporting of all matters relating to IP, and to apply appropriate protection mechanism. For example, for IP rights that have to be registered, you register them, all right? For IP rights that can be registered or can be protected without registration, you have to decide whether or not it is more beneficial to spend the cost to protect it by registration. You also have to establish a system to keep records for the protection of rights that are not registered. For example, copyright, trade secrets. You will, as well as business goodwill, all right? You have to prove such rights by using your documentation retained in the company. You also have to establish a system to keep trade secrets confidential. Whatever information that is already open to the public, you cannot protect it by trade secret law. You also have to establish guidelines for IP management and enforcement, and conduct periodic IP audit to ensure that the IP strategy is in alignment with business goals and development needs. For example, let's just take a look at a watch company, for example. Previously, they may be making mechanical watches. They have lots of designs for watches, mechanical watches. But suddenly, they changed to make smart watches. So completely different strategy will have to be applied. So for all IP in-house counsel or external counsel advising companies, you will have to help your clients recognize what is meaningful to them and then fine-tune the IP strategy from time to time. Now, IP portfolio management is also terribly important. It means good record keeping. For registered rights, of course, you have to keep good record so that you will timely renew and pay maintenance fees and do not allow the registered rights to lapse unless you want to let it lapse. And also you have to keep good records to protect unregistered rights. You also have to keep contracts with employees, licensors, licensees, and collaborators very tidily so that you can look for such information very easily. You will also have to formulate strategy or policy with regard to IP enforcement and defense. You have to enforce your rights against infringers, and you have to constantly monitor the marketplace to see whether there are infringers. You also have to defend infringement claims by third parties. However, you can minimize risk by clearance searches before launching new products. For contracts review and negotiation, pay special attention to the IP provision to ensure that the IP clause protects the company's IP interests. You also have to make arrangement for, your relationship with the other party to the contract before, during, and after the contract. So what are the rights of the parties before the contract? How do you preserve them? What are the rights of the parties when new inventions, for example, are created during the contract period? And what will happen after the parties part their ways? You have to allocate responsibility for costs associated with IP creation, registration, maintenance, enforcement, and defense. And you also have to consider dispute resolution mechanism with the company's business and IP in mind. So for example, if your company just do local Hong Kong business, then you can consider just using Hong Kong law, all right, and litigation before the Hong Kong courts, because that's pretty much the cheapest way of enforcement. However, if your business crosses the border, then you will have to consider what would be the best means to resolve disputes and make the judgment or the decision enforceable. So you may have to consider arbitration under such circumstances. And then you also have to take several proactive measures, such as keeping updated on IP developments. You also have to train your employees so that they are aware of IP and the importance of protecting IP as well. Now, Thomas just mentioned that there is an IP manager training program, right? So actually, companies can send their staff to attend the program and let the IP department train your staff so that they know more about IP and so that they can perform well. And finally, you can collaborate with IP Council so as to leverage on their knowledge and experience. So, I mean, for all lawyers, we know that we can't be jack of all trades. There are people who specialized in IP laws. So you look for those experts and work with them so that they can help you protect your company's IP. Thank you very much.
Thank you very much, Rebecca. So now, Alan, may I now invite you to do your sharing session? Thank you.
Hi, everyone. I'm Alan Chiu, managing partners of LLN. I also call it LLN because it's actually a firm founded by me and my fellow co-founder Ella, who is also here, together 7 years ago. We are a full-service law firm, but with an award-winning practice in IP, entertainment, and media and technology. Today, I'm going to talk about practical tips because we have talked about policies, about how the government extends the initiatives to protect IP. We have talked about, Rebecca has talked about the IP assets, the natures, and some tips about for corporates to manage an IP, but boil down to some really day-to-day work. What are we going to do? I don't have time to go through my bios and our offices, but you can see from the map here, I would say many of the law firms are actually doing the same thing, especially for IP firms, because IP is an international concept. We used to work with MNCs to help them to navigate the difficult waters in Hong Kong and mainland China, but now we are actually more to help the PLC clients to get out of China. So talking about IP is always about global. For example, our firm's name, Ellen or LLN, actually is a name coined by Ella and myself together, and representing the two of us and also representing the firm. But incidentally, actually, this is a name of a former king in Sri Lanka. So I'm afraid that if I want to expand our practice to Sri Lanka, we are not going to get the mark registered there. So do your trademark search if you want to do global business. And I think every single business is you now want to be global, because with the proliferation of internet, Web 3.0, everyone is doing things globally. So in Hong Kong, what is the benefit? What is actually happening here? We are having Madrid Protocol. Thomas has just mentioned that. It is an international treaty allowing Hong Kong people and Hong Kong companies applying for trademark registration worldwide, covering up to 130 jurisdictions through WIPO. So basically one set of filing fees, basically just tick, 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 and all done. And of course, your work is all done. And most of the work will be done by the local registries as well. But it's just simply a single step. But before that, because trademark rights is largely territorial, each and every owner has to file in each and every single jurisdiction before that. So this is the typical workflow. You don't need to really have a detailed memories of this. But what I want to say is after you have filed, the IPD will actually do the basic formality checks and all this stuff, and it will go through WIPO. And WIPO will actually send the papers to the designated IP offices. For example, if you want to extend to US, to the other some other jurisdictions, then they will do the same for you. But of course, it's not as simple as such, because one thing I have to highlight is you can see that there's a word basic mark. Basic mark means the basic registrations in Hong Kong. If your basic registration can't go through in Hong Kong, the entire chain collapses. So, oops, technical problems. I've changed the slides, but thank you for waiting for that. But due to time constraint, I'll keep it up. And I'm sure that Law Society can share the slides with you. And you can also email me and look up for my contact. So yes, here you go. Basic mark on the right-hand side or top right-hand corner. Basic mark, you have to get it registered first. Otherwise, the whole chain of international registration will collapse. So that is the benefit, because Hong Kong is relatively small. The number of marks involved, although we are having more and more trademark applications, but when compared to China, our numbers is still small. So the chance of getting your mark registered in Hong Kong is actually a lot higher, or the chance of not actually getting your mark rejected in Hong Kong is actually you have a slow chance of getting your mark rejected. So going through Hong Kong is actually the right thing to do. In the past, many mainland companies actually, they don't do international registrations in China because they are aware of the risk. What they do is they set up a company in Singapore and then go through the IR channel. But now they can go through us, Hong Kong. Sorry, the slides, okay. Yeah, but one thing I have to highlight, mutual destinations between mainland and Hong Kong are not allowed. That means that we still have to, if we file an IR in Hong Kong, we still have to file locally in China. Because we are one country, we are actually under WIPO, we can only designate other foreign jurisdictions. So here are some tips for cost, efficiency, whether you have in-house IP capability. These are all the key factors for you to decide whether you should go through this new IR channel or using the previous national filing channel. And we are not yet having all this implemented. I think Thomas can tell you more. The IPD is going down to doing the logistics, the fee arrangement, and getting approval from the central government right now. And it is expected to be launched probably later this year or the first quarter next year. IP commercialization, I don't have time to go through all these, but these are the key concepts. When you talk about IP commercializations, licensing, assignment, franchising, audit, due diligence, valuation. In particular, I would like to highlight if you are acquiring a company or you are going to be listed in Hong Kong, you should do the IP due diligence, audit, or valuation as early as possible, because that really affects the value of the company. And I've been assisting a lot of IPO teams of different firms because they can't go through the stock exchange requirements because they got stuck on IP. So these are the basic terms. I know probably in-house and also most lawyers like checklists, and these are the checklist items which you must have, or actually the basic ones you need to have in the licensing arrangement. Something you may not have thought about, for example, right to sublicense. How deep you can sublicense, the layer of sublicensees. Why this bothers you? Because if you have many sublicensees, that means that you may lose the control. Derivative works post-termination, I would highlight that post-termination is a key thing, because many, actually the business people, they usually focus on how good the future is, how good our collaboration is. But as in-house lawyers, you focus on the risk. You always say something bad or actually discouraging them to do the deal. But for post-termination, they have to go for it anyway. So what can you do and what should you do? At least give them some protection there. Put more sort of provisions or measures for post-termination arrangement. For example, like return or destroy the confidential information, cease using the IP, and actually in most jurisdictions, IP licensing has to be recorded with the registry. Do we have to cancel the recorder? Yes, you may need to do that. So these are the very practical ones that you may need to consider in IP licensing. I would like to save my time for IP documentation because, as Rebecca has mentioned, when we talk about IP, it's not just about registrations. You can see from the list here, there are a whole lot of corporate documents that may touch on IP, the control, ownership, validity, use, or sort of limitations of IP. And these are the key ones. Of course, there are a lot more. For example, if you have a settlement agreement for infringement actions, you may have a trademark coexistence agreement. These all go to that list. So no matter you do an IP audit for your own company or do an IP due diligence for another company, try to look for all these sort of documents. But I would like to highlight the last one, AI policy, because probably not that many people have been talking in for AI policy. Hong Kong court, actually US court, and many courts have already been using, or actually US court is penalizing lawyers who use AI for giving inaccurate information. What are the uncertainties here? So AI, of course, everyone knows confidentiality. You are leaking, or you may be leaking your company's confidential data or personal data, but actually there's more. What about if you are creating the work through AI, ChatGPT, Midjourney, whatever, you name it, does copyright subsist? Or even if copyright subsists, do you own the copyright or just part of it? Or you don't know how the AI come for this sort of AI generated product. So is that infringing or infringing someone's copyright or trademarks, or who should be liable? I think an AI policy would help. And these are the very quick pointers about the AI policy. It's not very exhaustive, but I would say that's the very fundamental basic stuff. First of all, read the license terms of the AI tools, because that contains usage term and IP ownership terms. And one thing I would like to highlight, ChatGPT, you are not allowed to use it in Hong Kong because you need to use it through VPN. But when you use through VPN, that means that you may be breaching the terms and conditions of ChatGPT. When you breach the terms and conditions, all the provisions do not apply, maybe. So the IP ownership, even if that the IP ownership vests on you, the user. But at the end of the day, no, that's not. Anonymize the data because it's confidentiality and personal data protections. Alert your staff that AI generated product may result in bias, discrimination, unethical, inaccurate, and illegal outcomes. So you need to exercise good judgment, or your staff have to. Use AI only to assist with your work, not to replace the intellectual input and efforts. Why? Because IP protections offers to those who put in efforts in creating the work. If you are not creating, why give you the IP? So at least you should have to use your brain to give instructions. Don't ask the AI, oh, copy that particular piece of article. I want 100% copy. No, that's definitely not. First, the AI tool is infringing. Second, you are authorizing the infringement. You have to be liable anyway. And you are the employer. You as employer will be liable too. And if you're using in the employment context or actually making money, commercial context, that may be a criminal offense. So you can see that how important the AI policy can be. And I have some tips. The second last bullet point, give specific instructions. Avoid copying. Why specific instructions? The more instructions you give, the more intellectual input you are giving. That means you may be classified as an author or at least a co-author, so that you at least, as a co-author, you at least have some rights to use it, or at least you own part of it. So that's as important. Of course, at the end, state clearly, ask all the staff, if you are using ChatGPT, tell me that you are using that. So at least you as in-house lawyer, you can manage the risk. And these are the repeated steps for about managing IP portfolio. Be involved from the very beginning to review, enforce, and I don't want to repeat all these, and I hope you enjoyed these sessions. Thank you.
Okay. Thank you very much, Alan. Yeah, thank you, Thomas, Rebecca, and Alan for a very insightful sharing session. I am conscious of time, that we are 5 minutes overrun, and also the fact that everybody here sat through 2 panel discussion sessions. If I may suggest, for those people on the floor who have questions, maybe you can reach out to either Thomas, Rebecca, or Alan, like privately when we have the kind of 25 minutes now, a sharing session outside, just mingle and have a chat. I think, Robert, that's the best course, right? And no objections, right? Okay, then thank you everybody for your patience. And yeah, so please feel free to reach out to Thomas, Rebecca, or Alan during the recess. Thank you.
Thank you, Alan, Rebecca, Thomas, and Arthur. May I ask you to remain on the stage as the Law Society would like to present you a souvenir? May we invite our Vice President, Mr. Roden Tong, again to proceed to the stage and present the souvenirs to our panelists. Roden, please.